And also I know we have some guests coming from the conference that is taking place of political sciences right next door. So I will be focusing my observations. I'm sorry, it doesn't work also, Veronica, to move to the next slide. I will be focusing my observations on the new screening, external asylum border procedures and border returns procedures, which were conceptualized as a kind of new seamless migration process at the borders. And I will be drawing from a policy study. Yes, we are here, so it's like it works now. So I will be drawing from a recently published policy study, which is a cooperation between the Odysseus Academic Network and the European Policy Center. So I am writing on this element, but our further colleagues have touched upon other aspects of the Pact. So do keep this series in mind, where you can find analysis on different files of the new Pact on migration and asylum. So 6 minutes, 6 points. I will try to be on time. One of the elements of this new procedure at the borders is this adequate capacity. So considering the blockage of previous years in terms of capacities and also of deficient accommodation at the border and of overflow, there is a kind of preparedness ingrained in the system where member states are supposed to build up EU-wide 30,000 places at the borders, but also this is to be divided to a particular number of places that they are to have at member state level. And this is through a very complex formula. So for example, Portugal may need to have, 2,000 spaces of these 30,000. This works on an inflow-outflow basis. So the point is that there should be this capacity on an EU-wide level at any moment. And when this capacity is reached, then there will be fewer categories of asylum seekers under the mandatory limit of the border procedures, because there are some categories of asylum seekers, such as those coming from countries with a so-called low recognition rate, that should be mandatorily placed in these proceedings. And for other asylum seekers that have just arrived, for example, irregularly at the border, this is just a possibility for member states. And then there is this maximum number of applicants on a yearly basis, in which case only those who endanger public order are to be placed in these procedures. So while these objective indicators could enhance mutual trust, they also signal also enhanced responsibilities for member states at the external borders, which is something that I believe we will come back to. The second point is funding. So all the instruments on the new Pact pay a greater attention to this kind of implementation and administrative governance side of the system. There are many mentions in the available EU funding that is to be pooled also to generate these capacities, services at the borders. And there is also a new solidarity pool. Veronica will mention more elements on solidarity later on, which could also include financial contributions at interstate level that could be channeled towards also enhancing capacities. But still, this should not take away from the fact that a lot of the financing and resources are still to come from the national level and national level budget. So we have not had some kind of centralization, federalization, or full compensation from the EU level. There are these procedures also generate concerns for the fundamental rights of migrants and asylum seekers. One of the elements is to what extent they will be connected, in fact, with deprivation of liberty. They are for sure connected with restrictions to the freedom of movement of asylum seekers, because they are to remain in designated locations in proximity to the external borders or transit zone or other designated locations. But one can begin then to question, will this be then in a regime where they have freedom of movement, otherwise they just have designated residence, or will this be closed facilities, and will there be a push for closed facilities where in fact they are deprived of their liberty? So the mention of the principle of necessity and proportionality are there, and they point to an individualized assessment. But of course, there is the fear that expediency and considerations on effectiveness might override EU standards in practice. While the practice so far with optional border procedures in the member states that had instated them were that those who were identified as being vulnerable, as having a certain kind of vulnerability, was that they would be exempted from this type of processing, both because of the location of the processing and the fact that often it is difficult to provide the services that are necessary in these locations, but also because there are curtailed procedural guarantees. This will not be the case under the new pact, so only unaccompanied minors are broadly exempted. For the rest of the categories, they could be exempted if the necessary support is not there. But in general, the philosophy is that member states should build up these special arrangements and safeguards to exist at these border locations. But then the issue is whether in practice this will be feasible and available. And if it's not, because in a way the burden then falls on the vulnerable individual to be exempted, whether there will be such mechanisms to be able to report failure to ensure standards. Among the curtailed guarantees are restricted rights around the right to an effective remedy in terms of very short deadlines to appeal the processing, but also appeals under the border procedure lack automatic suspensive effect, which means that a return procedure could kick in unless a court decides to grant suspensive effect to the appeal, which brings again a lot on the burden on the asylum seeker to request this suspension, to find access to legal also assistance to make these claims. And then it will be upon the court upon national courts to systematically see in each case whether they will grant this suspensive effect or not. In essence, needing to go into a bit the merits of the case because the principle of non-refoulement is at stake, without though having a full view of the case. And the final element is around monitoring of fundamental rights compliance. There is a monitoring mechanism that is linked with both this screening, initial screening identification phase, and the border processing. The issue is that while this mechanism is to have a robust and broad powers, including conducting spot checks and unannounced inspections, these are only to be made in locations where the screening and the border procedures are taking place. So it is not a generalized monitoring mechanism that could cover, for example, I don't know, the green border or other arrivals at non-formal border points, where in reality is where most fundamental rights violations are happening. And this mechanism will be called to collaborate and to these national mechanisms and with other monitoring. There is a proliferation of monitoring mechanisms through different also other agencies or other peer review mechanisms. And the whole point will be to try to find synergies in these instruments and not to create overlap. And we will see to what extent they will be effective in enhancing human rights compliance. Thank you.
So thank you very much. My name is Cláudia. As it has been said, I work as a legal protection officer at the Portuguese Refugee Council, CPR. For those who don't know, CPR is a non-governmental organization that provides free legal social integration assistance to refugees and asylum seekers here in Portugal. So I'm here today representing a bit of civil society to bring this perspective to the panel. My goal here, it's different from my colleagues, my panel colleagues, because I will not talk about just one regulation. I'm going to give you the stance that we have on the Pact as a whole, so that we discuss a little bit of the problematics that we see. So in our view, the results of the changes to the common European asylum system can be actually worrying, not least because they will most likely result in reduction of the protection standards in the European Union and impact on the fundamental rights of applicants for and beneficiaries of international protection in the European Union. Moreover, we don't see that this pact actually it has a stance on the unequal division of responsibilities between the member states. It does not change any of that, the unequal division that there is already. So the reform does little to solve these structural problems that were before identified, namely the failure to guarantee, to implement guarantees for asylum seekers and to address the problems related to the criteria's allocation of member state responsibility towards the analysis of asylum applications. And it has to be said that underlying all these instruments, there's somehow this sense that all of them want to hinder the possibility of effective access to protection. So in most cases, it makes it more difficult to access protection, which in our view is also inconsistent with the objective of the legal institute itself. It does not make much sense. So these new instruments will actually introduce highly complex procedures, will diminish the procedural guarantees that were already in some countries very low, and they will lead to an increase, as we already heard, they will lead to an increase of detention of applicants for international protection at the EU external borders. That goes without saying. So basically, and to give you a sum up and not lose myself, our main elements of concern that we so far identified, one never knows, but still so far is obviously, as I said, the reduction of the protection standards, the model based on containments at borders, and somehow the use of a substandard asylum procedure at borders, and the massive use of detention of applicants, and the disproportionate focus of all the instruments on the deportation, on return, the volume and complexity of the instruments, and I will elaborate on that further on. The use of derogations, so this harmonization that will eventually come up to the common European asylum system by using the regulation on force majeure. And the failure to address the previous already identified problems, which are not new in the European Union, regarding the responsibility sharing of the analysis of the applications, and also of the failure of some states to comply with the rules of the common European asylum system. We think there's also a big focus on externalization, somehow a punitive approach to everything the asylum seeker does, and the example is the withdrawal of reception conditions in case he or she changes the host country, which is, anyway, and the disregard for problems of non-compliance with the rules. We don't see a response to that. As we all know here, most of these legislative changes will have a direct applicability in national legal systems, leaving little room for national legislators to have a more guarantee-oriented or to lead to a more guaranteistic, a more favorable, and taking into account the specific needs of this population, of the applicants and beneficiaries. In our view at CPR, we do hope that this does not hinder, talking about Portugal now, but we hope it does not hinder the continuity of positive aspects of the Portuguese legislation that we foresee. For instance, here in Portugal, we have the obligation of communication of all the international applications submitted in Portugal to both the UNHCR and to CPR, which we think it's a good sign of transparency in the system, and that should be kept. And we do hope that these changes do not take us a step back from these positive aspects of the legislation. It is essential that all the implementation of these instruments is led by fundamental rights, by the respect for fundamental rights, and also by the fulfillment of all international and regional obligations that all European Union states are bound, specifically European Union primary law. And now taking a step into here the national scenario once again. And taking a step to the Portuguese scenario again. And I think it's important that we look at our reality right now, and to think that as a guarantee of the correct implementation of all these instruments, we need to have a proper, effective, and well-prepared authority, asylum authority. Here in Portugal, we changed our asylum authority, and the transition of competencies from CEF to IMA has been a bit troubled, has been inconsistent along the way. And this is somehow worrying, taking into account the big changes that we will have with these new instruments, with this new pact. So we just hope that the authorities come up with a solution to this and are prepared for the next 2 years for this important transition, that it's done correctly. Finally, and it's my last point here, it's been the last years in Portugal, basically, the asylum system has been nothing but underfunded, which is worrying. And in the year of 2023, this was particularly harsh on civil society organizations here in Portugal, which were obliged to reduce their response capacity, to lay off workers, and to contract debts towards service providers because of underfunding. So there's no strong asylum system without a strong civil society. And we think that this transition to this new pact, to the implementation of these new instruments, needs also the participation of the civil society to help going forward with this operational and normative framework, and with finding a way to resolve these possible negative consequences of the pact. So we do hope that civil society is also involved in the national plan for the implementation of this pact. Thank you.
Okay, so start the clock now. Thank you so much. Good morning, everyone. It's really a pleasure and an honor to be here. So I want to start by thank all Nova for the invitation to be here. I will keep it to the basics, let me say like this. I think it is important to start debating the basics, and then we can develop further one of the criticisms that rightly so my dear colleagues before me, speakers mentioned before. So first of all, allow me to explain what organization I represent here, because I think it's important. So the International Organization of Migration is a UN agency. It's been established here in Portugal before I was born, and I'm very young. So as you can see, in '76, we had the first opening of the IOM and have been working smoothly since then. But we are a projectized organization, meaning that in case we don't have projects, we close the doors. So I think also it's important to look to the background. Why do we have a pact? That's a question that we should ask ourselves. What happened in the European political arena that decided that we needed to have a pact? Because it's important, because that explains maybe some of the criticism that are here debating. So first of all, I want to highlight that this Sunday Pact, or the discussion, started 3 years ago after a tragedy that happened in the camp in Greece. A lot of people forgot about this, but this was triggered. Of course, there was discussions before, but the decision to the Commission to put here and say we need to do something happens after a lot of people died in the camp in Greece. Again, it's important for us to understand this because it explains how we reached that far as regards to the plan. And it was 3 years of, I would say, tough negotiation between countries. And this has reached out as the plan. Allow me to say something that is, I think, very important. If there is a topic that is completely divisive in European Union, is migration. I even say more. If there would be a topic that could end the European project, would be migration. I strongly believe on this. So the positive outcome, and I'm here also to discuss the criticism about the pact, the fact that they somehow reach out an agreement among themselves on the topic that is so divisive, it's positive. But we have to understand from the different perspectives if this would be the outcome that the migrants, above all, are not going to be still being respected. I have to say that looking to the pact, and I'm here on the International Organization of Migration, this should be called actually the Pact for Asylum, not about migration, because most of the measures that actually are foreseen are specifically connected to persons that are in seeking of the international protection, I believe. But nevertheless, the European background is the following, and I think it's important. So we have this idea spread among some countries and some European countries and some European parties that we are being invaded. I think you are aware of it. So unfortunately, we have heard a lot of populism against migrants, including in Portugal. We have seen this in the 2 past elections in Portugal. For some reason, in the history of our democracy for 50 years, this has never been a topic on the election and started to be a topic on elections because suddenly, unfortunately, and again, wrongly, unlawfully, they decided to associate migrants with insecurity. That is absolutely incorrect. Again, absolutely incorrect. We are not being invaded. And I'm not sure if I have told you, but we are not being invaded. Maybe this should be stressed out. We are not being invaded. So I would highlight this how many times I should, because I think we should fight this idea. And if you have seen the Portuguese debate on the parliament 2 days ago, you would have an idea that actually we are being invaded and there is crime everywhere done by migrants. Sorry, sometimes done by migrants, and that's simply not true. So this is the background. Including in Europe, we have more or less closely 447 million people. And the last estimated is we have among between 18 to 20% of migrants in Europe, including, of course, the Portuguese that live in France and the Italians that live in Spain and the Spanish that lives in Germany. So I would say that 18 to 20%, this is not an invasion. That's my humble perspective. Concerning to the pact, I mean, we have people that are much more knowledgeable than I, and much more interesting than I already mentioned. So, but I would highlight the 5, and again, coming to the basic, yeah, thank you. And then I will have more around about criticism, then I can share it a little bit more. But we have basically 5 big diplomas on this pact. I will put it simple, then my colleagues can develop much more better than I. So first of all, we have heard about the famous screening regulation. So this provides for a pre-entry procedure, hopefully to a quick examination on asylum profile. Of course, this, as my colleague here, has two sides on the same coin. Is the quick procedure going to take into account human rights of the person, or it's going to be so quick that you don't care about the person is in front of you? That's a question. It's a very valid question. But the objective is to take the basic information under this screening regulation of fingerprints, photograph, nationality, age, and facial image. According to what I understood, the health and safety checks are also carried out. Then we have the Eurodac regulation. Eurodac regulation will have, according to the Pact, a large-scale database that will store the biometric data that will be held under the first regulation that I've mentioned. We have then the regulation of the asylum procedures. This allegedly will have two possibilities, the speedy process and the traditional process to screen the asylum seekers. Then we have maybe one of the most controversial measures. It's about the migration management regulation about the mandatory solidarity. So I'm sure you have heard about it. So if you want to contribute, you can receive. If you don't want to, you don't receive, you pay 20,000 euros per person to a fund that will be managed by European Commission, and then supposedly will be applied for projects or to finance projects on the integration of migrants. And finally, but not least, the famous, and I believe that is one of the most dangerous regulations, the crisis regulations. And why? Because this crisis regulation provides, first of all, exceptional rules. And every time we talk about exceptional rules, we don't know what's going to happen, especially because basically they can suspend the application of the Pact if we see an instrumentalization of migrants, as we have seen with Belarus versus Poland, with Greece versus Turkey, or with Morocco versus Spain. So we need to know exactly what rules will be applied if that happens, or in the case of a COVID. Nevertheless, I don't have much more time, so I just wanted to highlight these five, in a very simple way, I may say, the five major outcomes of the Pact, and I will be looking forward for more debate about it, the criticism that can be done. Thank you so much.
Thank you. Thank you very much. Thank you for having us. It's an honor and a pleasure to be with you today. And I also say pleasure because you cannot see what I'm seeing, but I see a room full of intelligent, interested women in migration and human rights. And I'm very happy to see that. And I'm looking forward to also hearing your voices afterwards during the discussion. So I was asked to speak about the challenges and opportunities of the new Pact. And as we were talking about with Mariana yesterday, this is also the approach of the Fundamental Rights Agency, and I'm having a really hard time pinpointing the opportunities of the Pact. So perhaps we can think of centralization and greater EU coordination, but then again, there is so much flexibility left to sovereign discretion, especially with a solidarity platform, as we also heard. Or we can think of perhaps the independent monitoring mechanism that Lilian briefly touched upon. She also briefly touched upon some of its limitations, but then we can add all the problems we have with the already existing national monitoring mechanisms. And we see problems of underfunding, we see problems of lack of independence, and we don't, I mean, such a monitoring mechanism is toothless if it's not accompanied by independent safeguards or monitoring of the monitoring and appropriate funding. So it's not just civil society that is having problems with that. So we have also, perhaps we can look for opportunities in the swift procedures of the asylum procedures regulation, which are going to streamline asylum procedures, and cut down on waiting times. Not if the necessary prerequisite is lowering the standards and widespread detention and swift returns. So it is basically the more critical literature that resonates with me. And I think I'm in good company when I say that the new Pact on Migration and Asylum is bad law. And I'm not saying that because I disagree with it. It is bad law because it is full of exceptions. Creates an environment of exceptionalism. And I'm actually going to we didn't plan this, but I'm going to continue where you left off. So it is the parliament has taken a pragmatic approach to rush through the negotiations so that we don't get to the new parliament, because then we would see even worse results. And now the result is that we have 11 instruments, 1,400 pages of basically full of exceptions to the protection rules of international law and EU human rights law. And this exceptionalism, this is what I would like to focus on this intervention. So we have, first of all, the fiction of non-entry at the external borders, where you are supposedly in the geographical territory, but not yet in the legal territory. So you cannot also benefit from all the safeguards and the protection when you're a person before the law, as again, Marilou was saying yesterday. It creates an exceptional border regime, resulting in, of course, exclusion from the normal legal order, and also the priority of the Schengen Borders Code, which is to provide protection, even so allow access to people, asylum applicants, even if they don't have the proper documentation. And of course, it brings limitations to access to procedures, fundamental right of an effective remedy, etc. So, and perhaps the most controversial element of the pact is what Vasco just mentioned, the instrumentalization and the crisis regulation. It had a turbulent journey, this term. I eventually found its way into the crisis and force majeure regulation. Basically, instrumentalization became the response, the regulatory response of the EU to what has been discussed as the hybrid threats. And these are arguments that have been utilized broadly by Greece, by Poland, Latvia, Lithuania, Spain as well, and have also infiltrated the EU rhetoric. I mean, we could hear the EU commissioner, the Commission President Ursula von der Leyen, thanking Greece for being the shield of Europe a few years ago when Greece was shooting migrants at the Greek-Turkish border. So she later referred to the instrumentalization of migrants by Belarus as a cruel form of hybrid threat. And you see also this escalating. So during this, the annual State of the Union address, she stated, let's call it what it is. This is a hybrid attack to destabilize Europe. So also within this pact, the rhetoric has translated into legislation with the definition of instrumentalization, or the concept of instrumentalization becoming a legal concept. And included a very broad, very vague definition, very malleable definition in the Schengen Borders Code, and also the exceptional regime of the crisis regulation. So this allows a wide derogation from the protection standards of the Common European Asylum System as a whole, including the safeguards of the Reception Conditions Directive, the Returns Directive, Asylum Procedures Regulation, the Charter. So basically, upon the implementation of the decision by the Council, member states faced with a situation of state-sponsored migratory flows, so instrumentalization, will be allowed to adopt emergency measures, for instance, suspension of registering asylum claims at the border. So instrumentalization has been included as one of the 3 states of crisis in the crisis and force majeure regulation. First, we have crisis as mass influx. Again, mass influx, what does that even mean? We have absolutely no definition of no indications on how to calculate that. Crisis as instrumentalization, and force majeure, for example, COVID situation. So the special regimes are based on allowing member states to derogate from EU asylum law and human rights law, and a range of derogations they can request when faced with the situations. And important to remember here is that the crisis and force majeure regulation is not just one of the 10 instruments of the Pact. It is central to the whole Pact because it provides derogations from all other instruments. And they are so broad and so they're left to the discretion of the member states that it becomes dangerous. So again, with very clear, lack of clear definitions on instrumentalization, crisis, influx, we have no way of safeguarding the definitions of these concepts. So if we look at the structural bias of the concept of instrumentalization, it does not take long to observe that the political and legislative attention devoted by the EU to the phenomenon of instrumentalization is yet another example of this multi-crisis narrative that we have been experiencing in the last years. So it essentially normalizes and legitimizes the de facto derogations that were already happening in practice, see pushbacks, for example, or suspension of asylum applications at the Greek-Turkish border. These are human rights violations that were already happening on the ground, and now they're legitimized through legislation. So in fact, the crisis regulation reflects the natural continuation of the already existing securitization narrative. So instrumentalization is, the way I see it, the natural evolution of securitization. So according to the developing narrative, the threat goes beyond regular security, so beyond this already existing narrative of security, and becomes national security and defense matter. So destabilization of the EU as a whole, as von der Leyen put it. While securitization has also resulted in the related trend of co-migration, perhaps you're already familiar with it, instrumentalization does not only imply that the migrant is a criminal and a terrorist, or a potential criminal and a terrorist, but implies a threat that goes beyond that. It implies a threat to territorial integrity, political stability of member states and the European Union as a whole. So while the co-migration narrative deploys the language of criminal law, instrumentalization deploys the language of the law of war. So this can justify even more extreme responses, even broader derogations, and even more acute, or to defend ourselves against an even more acute existential threat. So the structural bias of crisis instrumentalization concepts is that they are necessary and unavoidable defense against this existential crisis, which places them in the realm of exception. And under this background, the legitimation of the concept of instrumentalization as a legal concept is dangerously vague. This dangerously vague legal definition in the Schengen Borders Code of instrumentalization, and the broad margin of appreciation left to the member states to implement these exceptions. And this can create a permanent state of exception, according to Agamben, but I'm not going to go into the theory now. What is now the challenge is the implementation of the new regulation, what we're going to see in the coming years, coming into force in 2 years, by the way. So we'll have to see whether and how these new biases will consolidate into law. If we look at Konskaniemi, the new frameworks in international law, new regimes are rarely there to rarely present as explicitly replacing already existing regimes. It is more often not replacing the old rule, but mainly an exception to the rule, to the old rule, which is gaining more and more ground until it becomes the new rule. And this is the challenge here. The challenge is the interpretation and the implementation of the concepts of instrumentalization, crisis, influx, force majeure, in accordance to asylum law and fundamental rights law, European and international, including the principles of proportionality and necessity. So very, very basic things. I'm sorry I have to say that. So the challenge is to avoid the creation of a new normal of extreme border violence and without a clause, which will have legal implications and can substantially reshape the EU area of freedom, security, and justice. So the challenge is not to not allow the creation of the new normal, not to allow the creation of a permanent state of exception. Or perhaps this is the opportunity that I was looking for, the opportunity for European citizens to give active meaning to their citizenship beyond market citizenship. So as active civic engagement in defense of EU values, challenging and shaping political processes. You heard it already from the Refugee Council, the role of civil society, and I will finish actually taking us one step further to the work of Sheila Ben-Habib on cosmopolitanism and how citizenship and citizens and non-citizens can actively engage to challenge domination. Thank you very much.
Fantastic. Thank you so much.
Can you hear me? Okay. Thank you very much, Veronica, for inviting me. Hi, everyone. Hi, everyone on the table. Happy to be here. So I'm going to discuss, 2 months ago, the European Parliament adopted, as part of the New Migration Pact, a directive called Standards for Reception of Applicants for International Protection, so the New Reception Conditions Directive. If you want to look it up, it's P9 TA 2024-0186. And why did I pick this specifically? Because we know that the way an applicant for international protection is treated when entering a member state is very, very relevant for the future chances to integrate in the host society. So it's very important the person is feels welcome, let's say, in the host country in order to have higher chances to integrate in the foreseeable future. So let me also say that this directive does not entail anything particularly new in relation to the common practices that are already implemented in most member states. There's one novelty, and that one is positive. It makes it basically mandatory for member states to screen persons for the vulnerability, including mental health conditions, including PTSD, so post-traumatic stress disorder. And we know this is important because it's actually not done in most member states, including Portugal. We interviewed many people either working with refugees or being themselves refugees, who clearly had some mental health issue, and no one had noticed for years after their arrival in Portugal. So it's not a bad situation for somebody who wants to integrate in our society. This is, however, in my assessment, the only one positive novelty contained in this directive. The rest is, well, what they basically do is taking stock of what member states do in order to discourage people from arriving in the first place, or to convince them that this is not a good place to be once they are unfortunately already here. And they do this through basically 3 instruments: limiting the freedom of movement, both within the country of arrival and, of course, across countries, and by withdrawing or threatening to withdraw material or monetary goods that people are entitled to as applicants for international protection if they misbehave. Now, what does it mean if they misbehave? This is also interesting because, as Mariana said, these all new legislative provisions entail a number of exceptions. I would say in this one specifically ambiguities. So on the one hand, it says, well, of course, detention is a measure to be implemented exceptionally. But then on the other hand, it says, okay, you can detain anyone who is at risk of absconding, so going to another member state because maybe they have family there. How do you assess if a person is at risk? So the person has never absconded, okay? She's staying put. But you may consider them as being at risk of absconding. Based on what? Well, for instance, based on they're having other family members in another member state. It's clearly written here. So on the one hand, they say this is like an exceptional measure, should only take it if, blah, blah. But on the other hand, the criteria they list could be literally applied to everyone. So anyone could in principle be detained. So if a state wants to implement like liberal policies towards refugees and asylum seekers, they're able to do so. If they want to implement very strict policies on asylum seekers and refugees, they are also able to do so. So this directive accommodates almost everyone, okay? The good ones and the not so good ones, if you want to put it that way. Also, some restrictions are likely to be applied straight away to any person entering the territory. Like the directive foresees that you can assign a person to a specific geographical area within the state territory. Like I'm arriving at the border, I knock at the door, I lodge my asylum application, and the IMA or whoever else says, okay, from now on, until we process your asylum application, you're going to sit at the Strada Strela. Okay, fine. How do they make sure that I stay at the Strada Strela? That I may have reporting obligations. Okay, reporting obligation may mean whatever. But some states, including my own, I'm Italian, have a specific way of implementing reporting obligations. Like a typical way is to oblige a person to report daily at all so and so many days a week at the local police station and sign into a register. Now, I'm an applicant, for example, for international protection. I've gone through whatever I've gone through. I'm here, I'm not here, I'm at the Strada Strela, and I have to report to police every day. This is my first impact with the whole society. And I still haven't done anything, I'm just here, okay, I'm just an applicant. If I try to abscond, or if I am at risk of absconding, there might be subsequent and more restrictions to my freedom of movement, including detention, or I can be forced to stay at a specific place, a hotel, an Airbnb, a flat, a room, whatever, and I still haven't done anything specifically. I'm just at risk of, okay? So I have 10 minutes. So basically this directive is based on the assumption that most people come here as so-called economic migrants and not as like real asylum seekers or people actually entitled to international protection or any other kind of protection. The first option is to convince people that this is not a good place to be. The second option is to convince people who are already here this is also not a good place to be. So this, again, this can be implemented one way or another. But if a state wants to implement this like strictly in order to really discourage me from being here, they can do so. And this will put a heavy burden on my chances to integrate in our society. This is what worries me most. Okay, thanks.
Thank you so much. Thank you so much, Gabriele. So what I will talk about briefly as well while trying to monitor myself is about solidarity. Some things have already been mentioned, so I'll try to go a bit quicker on some aspects. So solidarity has been, as you might know, presented as one of the core elements of the new Pact of Migration and Asylum by European institutions. So for instance, von der Leyen said that the pact, and I quote her, creates more solidarity with the member states at our external borders, but they will choose how best to do it. At the same time, she says, secondary movements within the EU cannot be allowed, right? So this is all packed in sort of one paragraph on solidarity. So keeping in mind this statement, I will briefly say why solidarity in the new pact, and especially in the asylum and migration management regulation, is very problematic, which basically means, of course, more challenges than opportunities. But I will nevertheless try to conclude with some sort of opportunity, but I'm not sure even if it's an opportunity that arises from the pact. It's related, but not exactly sort of as we might expect it to be. So solidarity in the pact is framed mostly in state-centered terms, but its approach not only fails to address the issue of solidarity between states, but as it's already visible from what my colleagues have said before, it also exacerbates the risks of human rights violations, which also means undermining solidarity actually with migrants and asylum seekers. So first of all, a major problem of the solidarity mechanism, which now finds a permanent place in the system, is that it functions as a pressure-activated mechanism that I would say saves the Dublin system from itself. So the Dublin system, as we know, creates disproportionate obligations for frontline member states.
this system not only persists, the Dublin system, but its flaws are actually amplified. This is because of the new obligations that arise in the member state of first entry, where an application for international protection must be made and registered. So now it's an obligation. Then we have shorter deadlines for take charge procedures and an expansion of take back procedures to beneficiaries of international protection. So all these changes will most likely exacerbate the disproportionate effect on frontline member states. So the solidarity, the so-called solidarity mechanism, is created not so much to deal actually with a high number of arrivals, war, migratory pressure, or significant migratory situation, as to use the terms of the new pact, but actually is created rather to minimize, allegedly, the disproportionate effect created and exacerbated by the new pact itself, right? So the reasoning is, we have a system that doesn't work, but we can keep it and even make it worse if we add a solidarity mechanism that allegedly corrects it, right? Now, does it actually correct it? The mechanism actually shows very little promise for really correcting it. So this is my second point. I arrive at the kind of solidarity mechanisms that are in the pact. There are three types of such contributions. First, relocations of asylum seekers and beneficiaries of international protection. Then we have financial contributions for actions in member states on migration, asylum, or border management, which includes support for actions in third countries with an impact on migratory flow to the EU, right? And then we have alternative contributions like capacity building, staff support, equipment, and so on and so forth. Now, not only these three types of solidarity measures are not of equal value as the new pact actually claims to, for it to be. It actually every time mentions the fact that they must be considered of equal value. But some of these measures, they promote the externalization of EU borders, shifting the burden to third states and fostering irregularization and securitization even in refugee-producing countries, which is, of course, very problematic from a fundamental rights perspective. Now, the issue is further complicated by the fact that with a solidarity system, while the solidarity system mandates contributions based on a distribution key, so the share of solidarity contributions is mandatory, it actually grants, as it was also mentioned before, full discretion in choosing the types of solidarity measures that states will provide, right? So I doubt that the relocation of asylum seekers will be the preferred solidarity measure, given the experience with the 2015-16 crisis especially. And I will conclude briefly with a thought on where to go from here, and with this sort of opportunity thought. The only opportunity I see in this complex system of purported solidarity is to persistently expose the system's hypocrisy. As we can in our different roles as academics, as civil society actors, as members of international organizations. So when I say hypocrisy, I think about the fact that the new pact's 1,000 and plus pages are riddled with contradictions, right? Commitments, they are made with one hand, and then they are quickly, immediately undermined with the other hand. So in my role as an academic, I see it as my responsibility to expose these tensions in the classroom through clinical activities like this roundtable, and as a researcher, of course. So this is my conclusion, and now putting my hat as a chair. Thank you. So now putting my head as a chair, I suggest that we do a quick second round. We might have maybe 3-4 minutes per person. And I would suggest to do it in a reversed order. Is that okay? Yeah. So so that basically means that I'm giving the microphone back to myself. And we're doing this in the reverse order. And what I wanted to pick up on, I think that what comes forward from all this great comments on the new pact is really, I think, what Mariana also put emphasis on, is this idea that we're in the process of normalizing something that was or is supposed to be exceptional, and that is extremely worrisome. And I would like to add something to that idea in relation to the border procedures, what happens at the border. Because the border procedures, they are supposed to be, they used to be optional, right? So now they become mandatory in some cases. So I just wanted to add that this is there are some criteria that some grounds of that allow that mandate its mandatoriness, so to speak, that basically means that in practice we will have mainstreaming of border procedures. And I want to just highlight one ground that is, I think, especially problematic. That is when asylum seekers, so I'm talking about border asylum procedures, when asylum seekers are from countries of origin with low recognition rates at first instance, understood as countries that have a recognition rate of 20% or lower, according to the latest available yearly union-wide average Eurostat data. So first of all, this is a criterion that looks to me, it seems to me that it's self-perpetuating. Self-perpetuating in the sense that the data will be used to reject, reject applications, right? And that sort of will be the rejection of applications, and will be used to sort of perpetually feed into this ground for border asylum procedures, right? So I think it will be a very difficult, it will be very difficult to challenge this criterion. So there is a possibility to challenge it in case the situation changes in the country of origin. And I would like to also highlight the fact that it's actually, it looks like the concept of safe country of origin comes into this this idea of low recognition rates, but without saying that actually it's about the safety of the country of origin, right? So, and this is extremely problematic because it's at least because it's contradictory with the very idea of what a safe country of origin concept is about in the new pact itself, right? So for determining whether a country is a safe country of origin or not, the pact, in continuation with the system that we have had so far, mandates sort of a context-specific analysis, right? So there has to be sort of an analysis based on relevant and available sources of information, including from member states, the Asylum Agency, the European External Action Service, the United Nations High Commissioner for Refugees, and other relevant international organizations. So this criterion of having this ground that is based on just a percentage without taking into account sort of a more contextual analysis clearly contradicts the very idea of what a safe country of origin concept should look like. In itself, I think it's also problematic, but let's at least sort of stop here that there is I think, a outrageous contradiction that is visible. So I will stop here and I will pass the microphone to Gabriele.
Oh, two, three. Okay. So picking up on something that I think almost everyone at the table said, what strikes, okay, of course, states or legislators implement policies through law. So of course, when you read like a legal text, there is like a political intent behind, and that's normal. While reading like the different components of the Immigration Pact, what strikes me is that I have the feeling, I'm not a lawyer, so maybe my colleagues might be a different opinion, but I sometimes have the feeling that in some cases at least, some relevant legal principles are bent or at least twisted to a political will that seems to be valid as long as states don't play too dirty, let's say like that. So as long as I don't overstep too much the boundaries of fundamental rights, I can do more or less whatever I want. It seems to me, but this is maybe my exaggeration, that the directives and regulations, etc., that compose this portion of the new Migration Pact are not meant so much to harmonize the whole system across Europe, but to permit different countries to pursue their own policies as long as they don't shame everyone else first, and as long as they don't cause problems to everyone else. Like, as long as I prevent secondary movements from happening, it's all fine. Okay, I don't know if the real lawyers at the table share this opinion, but okay, thanks.
Thank you. Yes, I would like to pick up on something you mentioned, Gabriele mentioned, about receptions and this idea of the risk of absconding, which to me is a nauseating notion when we're talking about asylum applicants. But then, okay, why should we care? We should care because Germany cares. And Germany cares about secondary movements because they are done having more applications, more asylum applications from secondary movement than they have from like first arrivals. And this is like Germany's influence. We see it here in the receptions, but we also see it especially in the Schengen Borders Code, which is an instrument that does not formally fit within the Pact, but for me, it is the 11th document, the 11th instrument of the Pact. It was also approved last May, and we see there exactly the same tendencies of exceptionalism, of legitimation of already existing, pre-existing de facto derogations, so basically illegal practices, accompanied with lack of effective safeguards and widespread increase of the use of surveillance technologies. And this time, not to close the external borders, but to prevent secondary movements, closing the internal borders. And we see there thin and blurred lines between what is supposed to be border checks and what's supposed to be police controls, that risks leading to a plethora of violations that are also very difficult to identify and thus remedy. You need to do it on a very on a case-by-case basis. These things are very obscure. There's again no suspensive effect of appeals. Perhaps I can point out like the four main changes that we have, but there is in general too much leeway to the left to the member states again to implement the exceptions at the internal borders. And we have first the introduction of the internal border controls that we have been struggling so much the last years with, again, this exceptional regime and member states introducing internal borders for prolonged periods. So until now, so the legislation of priorly what used to be illegal state practices of reinstating these prolonged temporary border controls beyond the 6-month period, that used to be the limit, the 6 months. Now it's legitimized in the Schengen Borders Code. So now secondary movements, which usually qualify as a secondary movements will qualify as an exceptional reason or as a reason for exception for the 6 months period. And this is translated as reasons of public policy, public security, secondary movements. And also secondary movements reach the activation thresholds for this exceptional situation of, or as we see it also in the Schengen Borders Code mentioned as a sudden large-scale influx, which puts a strain on the capacity of well-prepared asylum systems. You heard it from Lilian in the beginning. Again, what this means is under question. How is a system well-prepared? But this period, basically, we see it now, the period of 6 months being extended to 6 months and from 6 months to 2 years, plus another additional 6 months in exceptional circumstances. Again, exceptional circumstances, secondary movements can be exceptional circumstances. And this doesn't stop here. It can lead to an indefinite prolongation because every new, we already know that from Court of Justice case law. So every new threat to public security, so every new influx of secondary movements creates new grounds for the reinstitution of another 2.5-year period, and then another, and then another. So, and we also, it's also very important to look at what is presented as the alternatives for the introduction of border controls, because of course the Commission does not want or wants to avoid by all means the introduction of internal border controls, because the Schengen area then doesn't mean anything if there is no free movement. And what is presented as alternatives there is the new procedures for swift transfers. So this is what we used to call hot returns. So within 24 hours, if you're caught crossing the internal border, you can be pushed back. So these were the what we used to call the pushbacks at the internal borders, and they used to be illegal hot returns. Now they're not. Now they're swift returns, with the exception that you can accompany that with a return decision. So it should be in accordance with the returns directive. But what the problem is there, apart from the fact that it happens, and it will be part also of police controls. It doesn't need to be conducted by border control, so it doesn't come into the realm of reintroduction of border checks, as the police does it. Is also that you can appeal, but your appeal does not have suspensive effect. So you're going to be sent back anyway, and then at some point your appeal can be decided. The second alternative measure is, I mentioned already, the role of police controls. So police control is going to have a bigger role, or already does, but like it's legitimized, its role is legitimized at the internal borders. It's also noting here that favoring the enhancement of police controls in border zones is inherently inconsistent with the very idea of the Schengen area as a whole, and it creates this blurred line between border controls and police checks. And finally, we have extensive use in more extensive allowance of use of border surveillance, video surveillance, and other monitoring surveillance technologies at the internal borders, which are particularly problematic from a fundamental rights perspective. And this is also linked to already existence data exchange for police cooperation. So the amended Schengen Borders Code is closely linked to police cooperation, see the PRIM 2, and interoperability. So at this stage, we have 7 information systems at different stages of development linked to the interoperability framework. This linked to the Schengen, to the information systems of the Schengen Borders Code. It can create a very widespread environment of exception and fundamental rights violations at the internal borders as a whole. So I think we need to see those things interlinked. And finally, of course, we talked about the risk of absconding, because when that happens, when this risk is realized, we have, of course, if the secondary unlawful secondary movement does take place, we have as a consequence the withdrawal of reception conditions. There will be reception conditions at the minimum stage, but everything above the level of subsistence is being withdrawn as a punishment for your secondary movement. So this is the follow-up. I'll just leave it here. Thank you.
Well, I have so many things to say, but we don't have 2 minutes. So One thing that I haven't heard here, and I think it's important, is also to remind everyone that this European Pact needs at national level, country level, a national pact for the implementation. So it will be very interesting to see actually how would be this implementation plan, taking in consideration the different positions of different EU countries on the topic. So it is important to have, nevertheless, the same background exists. It's a European Pact, but I would very much be interested to understand how the countries will, even the ones who are against the pact, or even the ones who are against some of the measures of the pact, will have to implement it by themselves. It will be interesting to see from a political and sociological point of view, I would say. Concerning everything that was mentioned here, allow me just to add, in my, again, humble perspective, in a very general way, what could be also some challenges on the implementation of the pact. Some of them, again, already raised much more better than I could ever done by the colleagues that precede me. Concerning the mandatory solidarity, and I understand and I agree with your arguments as well. I would add that according to some organizations, they believe that this mandatory solidarity could even generate between member states more tensions instead of solving it, as you mentioned, and in the end will not solve the lack of cohesion in relation to migration issues, and that's true. So instead of helping, might not have the other side of the coin, let's call it like this. Regarding and I've mentioned this briefly, the expedite asylum procedures, of course, very rapid processes can and could compromise the rights of the asylum seekers and lead to an unfair deportations. You have raised this as well very well, and the colleague as well. So this is something that we should highlight very clearly, that cannot happen. Also, critics have been done concerning the return policies, because in the end, they mentioned very clearly, maybe we are returning someone that might not be fulfilling all the criteria to be returned. So this is, again, something that needs to be looked very carefully, because as I mentioned in the beginning, if you have speedy processes, you have speedy decisions, and we are all aware when we have speedy decisions, you might have jumped to conclusions that are not the correct ones. And for me, from my legal perspective, and this is something that I haven't maybe studied enough, but maybe my colleagues have more knowledge about this, is for me still not clear if you have a denied process, if you can apply or not, into who you can apply in case you face a decision. Basics on law in every first year would say that for every decision you can apply. So I'm wondering exactly to who can a person that is in Cyprus and has been denied to enter, exactly to who or she or he can apply for or appeal for the decision that was done. Some of the other critics are, of course, the integration process that actually sometimes is foreseen is not enough, not sufficient to deal with, and there is clearly a lack of political will to invest on integration. There are some countries indeed that do not invest enough on this, and then we see the results. Another criticism that I've heard is, of course, that increasing, of course, the border control as if foreseen, and you mentioned very clearly, can result in human rights violations, and again, does not underline the root causes of migration. Because in the end, this is also that should be accompanied with the pact, is trying to understand the root causes of migration, although everyone is legitimate to have better life, have their studies continued elsewhere, to have their health treated elsewhere. But it is important to understand why people migrate and take so many times risks that unfortunately sometimes lead to death. I've said this even yesterday on public television. I don't understand. People do not put their son, their wives, their husbands, their granddaughters or grandmothers in the boat just because they feel trapped. It's because they feel that's the only way they can to reach what they want. And so it's important again to highlight, and I've done this million times, even before the pact was trying to negotiate it, the importance of having legal routes. And please don't come to me and say, well, we don't need migrants. It's exactly the opposite. We need the migrants. So if you need the migrants, and if you take that assumption from the beginning, let's discuss how can they come to Europe or whatever they might want to come in a humane and orderly way without putting their lives in risks. So again, some criticism as well have been said about how can the pact can prioritize control over protection. I think this is very clear actually from the outcome of the pact. And finally, but not least, the crisis responses might be, for me, it's also very tricky from the legal perspective. It's not clear what they can be considered completely exceptional causes. We know what is exceptional causes. COVID, it is exceptional causes. Instrumentalization of migrants can be an exceptional cause. But what is just the degree below that? Is it what? Is it instead of 20,000 people sick, is what? Is 100,000 people sick? It's 975,000 people sick? What is it? What is it exactly that can trigger an exceptional measure to be applied? So this is again some of the criticisms that I've looked and I've read and I raised here because they can put in risk some human rights of course the migrants and the asylum seekers and the refugees that just are fleeing away from the war or whatever they might be fleeing away. Thank you.
Back to me. So this was really interesting to hear all of you. I'll just go back a little bit and before taking some points in, the purpose of the pact was, and I was looking here again to the Commission's documents about it. The purpose of the pact was to bring harmonization to our systems between all the European Union countries, and especially to bring clear asylum rules and EU standards for refugee status qualifications and guaranteeing people's rights. Maybe I was not very positive in my first intervention, so I have to bring something positive of the pact. Finally, yeah, I know. Which is there's a lot of, they give a lot of importance to providing legal information at all stages to the applicants and beneficiaries of international protection. Many of the regulations talk about that. And that's great. And that's something that it will not be the state doing most of the times. What I think the problem is that when the system is not harmonized and we have a lot of exceptions, it brings the purpose of providing legal information a bit difficult for the people who do it, because you never know what to count with. The fact that we can have a person arriving in January in the exact same place as the person arriving in September and having two different treatments makes it very hard to make this predictable, which was the purpose of the pact in the first instance, was to make clearer, predictable procedures. And if that's not the case, that makes it very hard for the people to know what's going to happen and what are in fact their rights. So that's something that we hope that during the implementation of the pact, that and I speak about the Portuguese state, but all the states take a firm stance on the adoption of this regulation about these exceptionalities. One thing that Veronica talked about and about data and how that will have an impact on the analysis of the asylum procedures. The thing that I think it's most interesting is the last time I've seen an analysis of an asylum application should be impartial, should be objective, should be individual. And so this difference between the applications and the place where they are presented and the nationality of the person makes it a bit hard to do it in that way. That's one stance that I wanted to make. Regarding the notion of solidarity, the only way of having effective solidarity among member states is by effectively sharing the responsibility for analyzing the cases and not paying off your duties to go away. And that's the only way also to guarantee the effective protection of the persons that we should be looking after and that we should be trying to protect. Thank you.
So we've heard quite a bit, and as a last speaker, I have a heavy duty in trying to instill maybe some sense of hope and where do we go from here, the way forward. So, of course, I don't see this as a role of minimizing any of the criticism that we raise and to say that this is all sunshine and roses, but then just to say what can we draw, what can we work with from the new pact and from the general situation that is surrounding it. So first, yes, indeed, parts of the pact are bad law, but it's not only bad law. So there are also within their procedural guarantees, fundamental rights embedded. So the issue is whether they will be implemented in practice, whether they will be realized, or whether they will be overshadowed by other considerations, political efficiency, etc. So as all of us, and we represent here different actors, so that means as national governments, administrations, academics, civil society through strategic litigation as well, international organizations, have a role in making sure that these instruments with their deficiencies as they are in their legal design as well, but that they are implemented in a protection sensitive manner, and that the guarantees that are there are actually realized and do not remain a dead letter. So that's one. Second, and that was not touched upon, so one of the positive elements of the pact is that it gave for the first time attention in the administrative governance of the system. So how do we fund implementation? How do we implement this? Let's create permanent governance structures to decide and exchange on solidarity. Let's try to apportion responsibility, for example, at the external borders for this adequate capacity that I mentioned based on objective indicators. Let's try to create permanent structures in order to activate solidarity. Also within as we heard, this emergency regime that has several faults in the legal design, there is though a structured regime of communication between the member states and the Commission, notification in order for this to be activated. So there is something to work with. The fact that from ad hocism, so now we have, a boat of people have arrived and solidarity is, let's see, ad hoc, the governments contact each other, I'll take 12 people, you take 10. So this, from moving to this to a permanent governance structure is something that we can work with. And the fact that for the first time, interstate collaboration, administrative governance, implementation, there is a more serious thinking around this is something to take forward. Then, and here is where I mentioned the broader trends and context and where we should also focus our attention, academic, scientific as practitioners, is the broader trend of externalization. So already a few days or a few couple of weeks after the pact was agreed, 15 member states said, yes, yes, the pact is fine, but what we actually want now is third country deals to try to externalize protection obligations to third countries within this cooperation framework. So we should also, other than the instruments of the pact, their implementation, the governance that I mentioned, we should focus very much on what is happening in these cooperation frameworks with third countries, on what kind of association, let's say, and collaboration frameworks, also through funding, also through policy linkages with different issues. So trade, macroeconomic policy, migration, everything is coming together. So we very much have to draw our attention to scrutinize what is happening there in order to hold this process to the greatest scrutiny, transparency, and accountability that is possible, in view of having sustainable and mutually beneficial partnerships, and not only a short-term vision of let's externalize protection obligations, let's try to ensure that people go somewhere else, but to see things such as sustainable development, co-development, equality, so migration as decolonization, some people have said. So migration as an equalizer, also in order to perhaps address to some extent past injustices. So instead of it being just a short-term solution of externalizing protection needs, to see it as a broader mechanism of cooperation that will bring sustainable partnership with the third countries in a more equal footing. And a final word on populism, because we cannot also, with the latest results of the European elections, not discuss this elephant in the room. It is how to move the debate from where perhaps instrumentally some individuals want to take it, with migration as the issue, with migrants as the let's say, the problematic elements, to the issues that are actually underlying all this disenfranchisement. So social exclusion, the rise of social inequality in our societies, and to try to see how we discuss the underlying issues and try to find holistic solutions on those, rather than just allowing some portions, let's say, of politicians displacing the debate in targeting particular groups that are often vulnerable groups within the society, to place them some kind of burden, responsibilities, to put them, let's say, to other them, and to say, the problem is migrants are taking your jobs, or migration, rather than to say, okay, what is happening in our societies with growing inequality, with social exclusion, and how do we holistically tackle these issues. So that from me.
Wow, thank you so much, Lilian, for this fantastic conclusion. I'm really happy that you had the last word. It was really great to conclude with some glimmer of hope, even also, but not just of hope, but with a lot of responsibility, actually. So we have a lot of responsibility to take ahead of us because of the challenges created by this environment. That is not just about the new pact, but also about the populism. So now we'll open the floor for question and answers, and we have 20 minutes. So we'll start with those who are physically present, and then we'll move also to the Zoom if there are any questions there. Yes, Tatiana.
Good morning. Thank you very much for all your presentations. Congratulations, Veronica, for organizing this roundtable, and thank you for sharing with us your work and your views on the new pact. So I have a few questions.
One is regarding tensions, which you mentioned, and I find it very interesting. So I was wondering if you would like to elaborate more on the national interests of each state member versus the international obligations, namely their obligation to, because more, the ratification of 1951 Refugee Convention and other international treaties. I was wondering if you'd like to delve a little bit more about the national interest presented as security issues versus the international obligations to provide protection to refugees and asylum seekers and migrations to migrants too. I mean, if we look at it in a broader way. So that will be one, the legal tension, and the other one regarding externalization. I was wondering what you think about the influence of the UK policy on asylum and migration on the EU asylum and migration policy. So the EU left, and yet they seem to have a great influence, or at least EU is looking at the UK and what they are doing, and somehow replicating to a certain extent their decisions. And lastly, I would also like to wonder what you think about the creation of the EU coordinator for solidarity. What do you think the impact will be in reality? Thank you so much.
Hello, thank you very much for your presentations. I'm Vasiliki. I'm currently a PhD candidate at Queen Mary University of London. And I want to highlight another approach that I witnessed during the negotiations on the Pact and discuss something on this, that the derogations in the crisis regulations, but also other exceptions, were many times presented as a form of solidarity for member states at the external borders. And this is also explicitly mentioned in the Asylum and Migration Management Regulation, that solidarity can also take the form of derogations. So I could not really understand how this will help the external border states. I mean, even if we can derogate at the external borders and we provide substandard asylum procedures and degrading reception conditions and have reception facilities that are full of asylum seekers and they live in these degrading conditions, this will not in essence help the states. And I witnessed many cases, of course, in the European Court of Human Rights that say that even if we have significant numbers of arrivals at the external borders, this is not a reason and it's not a justification to derogate from minimum standards. And there have been many cases that the court has found a violation of Article 3 of the European Convention on Human Rights. So even if we have this crisis regulation, which will justify and legitimize these derogations, in practice, still, I think, and this is something that I would like to ask if you think how the court will actually react in these cases, because this may lead indeed to degrading treatment. So still, even if it is allowed from the states to derogate from these standards, in practice, still there may be many cases against external border countries mainly that will have to provide these substandard conditions to asylum seekers at their borders. Thank you.
Migration brings large net benefits to Europe. This has been amply shown, I think. How can we best communicate the benefits of migration in our own countries? Difficult. All right, so if there are no other questions from the audience, we can perhaps give some short answers to questions that last.
Okay, I'm not going to answer all of them. I'm going to give perspectives in two so that and then we move on with others who may want to pick up different points. So first on the UK policy, I presume you refer to the Rwanda plan. Well, this is influencing not EU on so much on an EU-wide level yet. It is influencing, though, very much on a national level, with several member states now beginning to have these visions of this kind of bilateral deals, such as the UK-Albania deal, which is not yet operational, as in that there is processing. The latest I heard, it was mentioned that maybe it would start in November. But this is creating this type of appetite of not only so-called safe third country approaches, but kind of externalized processing. So where the processing would happen in a third country. In this case, Italy is trying to operationalize a deal with Albania. So these policy visions, because for now they have not become reality, have been recurring since 2003, with several member states proposing and trying to propose this kind of externalization deals in the sense of offshore processing. They are quite complex in terms of both legal, financial, and practical implications once they are placed in practice, because the authorities of the member state or of the country that would be seeking to undertake something in the sense of the Albania-Italy deal are responsible in terms of fundamental rights violations, because the individuals would be under the control of agents of that country. So they would be operational on the ground, of course, with its permission of another country. So while there is this kind of, let's say, policy transplant in theory, I am very hesitant on whether this was more some kind of communication or policy bomb, let's say, on the side of the government that decided to do this, than that it will be practicable and operational on the ground. So these are not new, these are recurring visions. The UK government was one of the governments that already back then in 2003 had this visions and plans, and they do come back. It is a kind of circular process for those of us who have been around longer within the field. But then they are usually, in terms of the extraterritorial processing, the fully blown extraterritorial processing component, they are usually not realizable because of their implications. What is happening, though, is this. And what I do think that will continue to happen, which is why I said we must draw our attention there, is this preemptive approach of externalization before even blocking, let's say, migrants from arriving in Europe. So the more preemptive approach, where we see the enhancement with these third country partnership deals, cooperation framework, which is why I say that we should draw also our attention there, and in trying to make them into holistic frameworks of cooperation rather than a short-term vision of just deflecting migration obligations. The second point I will mention some words on is the EU Coordinator for Solidarity. So this is one of the elements of the enhanced administrative governance that I mentioned. So this kind of role of the EU Coordinator for Solidarity with the Solidarity Forum, which will work on a political and on a technical level. So this is a step forward in terms of the governance of the implementation perspective in relation to ad hoc bargaining or in relation to full absence of any kind of coordination happening on these issues. Of course, with the limitations that have been mentioned so far, that solidarity is intrastate, and so the individual can only indirectly benefit from a potentially, I don't know, enhanced conditions, but it is a state, intrastate vision. And second, also with the fact that we will need to see once it starts operating, what will be the balance between people sharing relocation, financial contributions, where what will be the volume of these financial contributions, where will these financial contributions be targeted? So will they be spread evenly on different focus areas, or will they just focus on projects on, I don't know, just return or external border processing, or even financing capacities in third countries? So there are many question marks. I was not meaning to sound uncritical in the end, but of course, the fact that we have a governance structure which is permanent to begin with, I think that this is an important step in itself and something to work with, to give it more meaning.
Thank you. Taking in what Lilian said about externalization and about the preemptive approach. So what we clearly see here is that internal politics inside the EU are also having effect on its external action. So the countries that the EU is choosing to take a stance on, Morocco, Mauritania, etc., are not just because it's a means of preempting people from arriving in the EU and acting as a stop country of the fluxes, of the flux of persons into the EU. What we cannot forget in this point, and this would lead to an interesting legal conversation, is about and this coming again to the externalization, it's about the principle of non-refoulement. Even if we send someone to the other country, like for instance, talking about the UK and the agreement with Rwanda, the principle still abides for the first country, to the country who sends the person. So the obligation still exists that that person cannot be sent back to a country where he or she is subject to harm, even if we are cleaning our hands and sending the person into another country. Regarding the point of detention and the obligations of the state, I do hope that the countries, if this is the path we are choosing and taking for ourselves, we need to have infrastructure for this for these border procedures, which at this point in time no one has, I doubt. And so we need to abide by all our international and regional obligations. And we're not talking just about international, even at the EU primary law, EU case law, everything, European Court on Human Rights. We need to abide by all that when assuring this, the treatment of these people. And most importantly, and here I talking about our national scenario, we always have a criminal court that needs to ratify the detention of the person. And so this will bring the attention of the criminal court also to look at the cases individually to see if it's necessary, to see if it's adequate, and to see if the detention is proportionate. It's not just saying, yes, that's the procedure as it is. They have to look into the individual case to see if all the necessary requirements are abided by. And finally, I will leave the last one for you. Yeah. What was I going to talk about? Yes, I talk about, no, I was looking at the derogations, but it's the same, it goes in the same line as the answer to the detention about the court obligations towards the rights of these, the fundamental rights of these persons. Okay.
Thank you. Yes, I will try to make a bullet point contributions to perhaps all of the questions that have been raised. Yes, the tensions, securitization, fundamental rights. When we're having this conversation about how the fundamental rights violations are intrinsic in the concept of securitization, I always think of the statement by this quote by François Crépeau and Pact, that borders are porous by nature, and any kind of effort to block them, to block these porous, will lead to levels of human rights violations and violence that are incompatible with a democratic society and the rule of law. So we start from this premise And then we're trying to explain basically the assumption of securitization, which is the basis for all these developments we're seeing in the last 30 years, 25 years. And then trying to make the bad situation a little bit better with fundamental rights safeguards. Now, with respect to the influence of the UK policy, some things have been mentioned already. It's not just the UK Rwanda deal, but it's also the illegal migration bill. And there we see also the parallels with the border procedure and the notion of non-entry and the widespread detention, which, yes, in the UK, in the illegal migration bill, it's brought as a punitive measure, and in the Pact as more exceptional, practical, to avoid absconding, to facilitate administration, but the effect is the same: widespread detention and speedy return. With respect to the UK Rwanda deal, the positive thing, and where the UK policy has not had an influence in the Pact, is on the asylum procedures regulation, and the fact that the connection criterion still remains. So this is still the greatest differentiation between EU law and UK law with respect to the definition of a safe third country. In EU law, we have the extra requirement that in order for the country to be considered safe, the returnee needs to have a bond with that country, be it cultural, family, et cetera, et cetera. So this is still there. And there was a risk that this was going to go away in the negotiations. This is still there. So, but still, at the national level, we have it in the Netherlands right now. The discussion on a Rwanda deal is very vivid also in the German parliament. Several other countries are thinking about these deals. It is for political consumption, but it's a very real risk. And the fact that the UK is trying to override a Supreme Court decision and use Coggins international law with national legislation puts a dangerous precedent. But the good thing is about that is that everything is most probably being put on pause with the new elections, because the Labour is not going to bring forward these measures. So Vasiliki, yes, very good point. Thank you for making it about derogations being presented as a form of solidarity. So basically relieving the pressure for the member states. And with respect to the role of court, what I want to emphasize is just going again back to the basics and the Kelsenian pyramid of norms. The Pact, the instruments of the Pact are still secondary legislation. Even if they say that there is an exception to the fundamental rights framework, it is the charter and the interpretation of the charter that will determine whether this exception is legal or not. So this is the role for the court, but I would say there is a greater role for national courts in order to enforce and implement these standards, and only send preliminary questions when absolutely necessary, when the law is not already clear. So I'm not sure that preliminary questions will help in this regard in the current political climate in the Court of Justice. And of course, we do still have the European Court of Human Rights, and they don't care about the exceptions of the Pact. And finally, about the communication, very, very, very tough question. Mainly because in issues of migration, it turns out very often to be an irrelevant one, because we are doing really good work. We're providing so much evidence-based recommendations for policy, and we're being ignored. And I would like to refer you to the very interesting recent book of Payne de Haas, a sociologist, about the myths of migration. And he's also very engaged in the policy debate, and always speaks with politicians. And he was saying how very often after his talks, politicians from both sides come to him and say, yes, this is amazing. Yes, thank you very much. Very eye-opening. I absolutely agree. There is no way I'm going to say that out loud. So basically the battle is, I mean, I'm not saying let's stop doing policy work. I'm also very, very much involved, and I see the relevance of it. But the real battle is on the ground, on public opinion, and this is a role for all of us. It's not an expert thing. It's about communicating and discussing and just keep putting the message forward. It is, these are very difficult times in terms of populism, in terms of political dynamics, but we cannot afford to stop discussing this.
Yes, very briefly. Yes, 1 minute. First question. I don't think that the pact is incompatible with the duty of international protection, but I think it might, some ways of implementing it might be at odds with human dignity. So if you want to humiliate a person either at a border or on your own territory, you have plenty of options to do so. And I think that's you don't have to do so, but if you want to, you may. Okay, based on these provisions. I think this is the intention. So to make it clear to you that if you're welcome, you're welcome, but if you're not, you're not, and there's no way you are going to be welcome based on law or anything national, international, whatever. No, we are just not welcome. You have to leave, go away. Third question, the benefits of migration. To some extent, that's a myth. Okay, so many people coming in are unskilled. Some of them are barely literate. And I don't think, okay, I'm a philosopher. I don't think they have a right to be here because they're useful. I think they have a right to be here because the world economic order is heavily biased in favor of the global north, and we have to give back something. So we don't have to expect them to be useful to anything or anyone. It's just a matter of justice, okay? So, of course, we will never say that on television or in a public statement, but it's the way it is. Some of them at least have a right to be here, although they don't serve the economy. That's at least my vision. I could explain more, but okay, it's a woman.
So unfortunately, we have no more time. We're coming to the end of this wonderful roundtable. I want to thank again the speakers for their insightful contributions and for a very rich debate. It has been a pleasure to have you here today. Thank you so much.
Thank you.